Good morning. This is the class for chapter 3, and it is titled Dispute Resolution in your book, starting on page 59. It's very important that you do read this chapter. There's a lot of technical stuff in this chapter, and I'm not going to lie, it's really dry stuff. I'm going to even try to fit this in one class. I don't know if we'll be able to do that. We'll get through part of it, a good portion of it for this class. But it's very important that you read this chapter to understand how the entire court system works, so that you can understand the rules and processes, and it'll help make a lot of the class make a lot more sense. So I'm going to go ahead and share this. So I'm not going to lie, I didn't even make this look pretty because the stuff's dry. It's irrelevant whether it looks attractive or not. You're going to have to just, trudge through this stuff. And if you find process really fun, I like the process of things. I like knowing kind of, a schematic of how things works. And that's really what this chapter is about. But it explains the entire way the court systems work and how a case ends up going to trial, which is actually fairly interesting. But some of the stuff that we have to get out of the way are just some, details about the kinds of courts, jurisdiction, all of that stuff. And once you understand that stuff, then the courts and the trials that you're familiar with now will make a heck of a lot more sense. So we'll start with the case facts that are on the very first page of this chapter of chapter 3. It's very important to understand this case because we'll refer to it throughout the entire class, so that we can have an example to compare all of the court stuff to. So the facts of this case are that Tony Caruso was out for a walk with his dog on the beach. He didn't come home for dinner. His wife, Karen, went out to look for him. Several hours later, after they find the dog tied to a fence, his body washes ashore. There is water in his lungs. Obviously, he is deceased. A doctor concluded that he accidentally drowned. Tony was also a business partner with someone named Beth Smiles. And so when it was discovered that Tony was deceased, Beth, after the funeral and all of this stuff, filed an insurance claim for Tony's death for $2 million because his death clearly affected their business and her and all of that stuff. So she had a policy on Tony. So when she filed the insurance claim, the insurance company replied and said, "We're liable for Tony's death for $1 million according to the contract. If his death was accidental, it's $2 million. If he died by suicide, we don't have to pay you anything. And based on our investigation as the insurance company, we think that he died by suicide, so we don't owe you anything." So obviously, Beth is upset. She calls her friend, who is an attorney, Chris. Chris doesn't really understand double indemnity insurance claims. It's not really his forte. It's probably just a friend of hers, maybe that she knew from college. So Chris calls someone who's well-versed in these double indemnity claims, and her name is Janet Booker, and she's a litigator. Litigators are lawyers that handle court cases. There are a million lawyers for all kinds of reasons, and very few of them actually go to court and litigate. Janet is one of those people in this instance. So this chapter is going to talk about dispute resolution. And really, for the purposes of this class, there are two kinds. So one of them is litigation, which is filing paperwork in court, and then with the purpose of going to trial eventually. So we're going to focus on the litigation process for most of this chapter. But also, towards the end of it, we'll talk about alternative dispute resolution, which is, it can be formal, it's informal, but it's any way that the parties decide to settle disputes without having to go to trial. So it's important to know how our systems work. It's important to know how the court systems work in general. You have to know where to file a case, or what case can hear your claim, or where you're supposed to be. And we have, there's a court diagram in your book on page 61. But here's also a diagram. This is kind of just a general way that things work. Like small claims courts at the very bottom, if you're suing over things in Kansas, I believe are under $4,000. Or, there's criminal court here in the lower one. There's family court for divorces, things like that. And then you go up to trial courts where once they're out of those, they go to trial juries, things like that. Those are trial courts. Then there's an appeals court, and then there's a Supreme Court. So this is a typical state system. And, there may be additional types of courts in there, but this is a standard one. So trial courts are the things that you've mostly seen on television. So trials are there to determine facts of the case. So they hear witnesses, evidence is discussed, it's shown, that sort of thing, so that the jury can decide what are the actual facts, what actually happened, who did what. And then once those things are determined, then the law can be applied to them. So in our sample case, we're talking about Tony's death. The trial court is going to decide, how did Tony die? So we're going to bring evidence into court during trial about why we think he died accidentally, and maybe the other side's going to bring in information about why they think he committed suicide. And then the jury is going to say, okay, did he drown by suicide? Was this accidental? Was it suicide? That sort of thing. So once those facts are determined, then the law is applied to those. So if it's determined by the jury that he died by suicide, and then Beth's not going to be paid anything. And that makes the facts incredibly critical. The smallest of details can make a massive difference in any case. So let's say, for example, in our sample case, let's say that that the doctor has a heroin addiction, and it's caused numerous problems in the last 5 cases that he has made a determination about the death of a person. If we never discover that fact, then the insurance company is out $2 million because we have an unreliable doctor. If we become aware of those facts, then then Beth, Tony's partner, likely doesn't get paid because we have a very unreliable doctor. So it's important to know all of the facts, even if we think that they're trivial or small. Jurisdiction is how you know which court can hear a case. So some courts have really limited jurisdiction. So the subject matter that they can cover is like one kind of subject. So say juvenile court can only hear cases involving minors. That's called subject matter jurisdiction. So small claims can only hear things, I believe under $4,000. And of course, there's civil issues. Probate court deals with matters of deceased people, that sort of thing. Criminal, here's criminal cases. These are subject matter jurisdiction. But trial courts have limited jurisdiction. So the ones we were just talking about, the small claims, juvenile court, probate court, those are called limited jurisdiction. So in Kansas, for example, and I think every state varies, but obviously Kansas is $4,000 for limited action in small claims court. So for general jurisdiction, these courts can hear a broad range of things. So for the purposes of what we discussed in this class, and for this case specifically, we're in the general civil. So now we know in the first chapter that the court system is split into 2 different systems. We have the criminal on one side and civil on the other. So we're in general civil. So that's sort of, I'll try to apply, all of the things that we've learned before so that it paints a clear picture of, why we're in certain places. But then the court also has to decide if they have personal jurisdiction. And I think this can get confusing for people. But essentially, personal jurisdiction means that the court, or the judge, has the power or the authority to make a decision that affects that specific person. So the person, for example, must live in that state where the lawsuit was filed, or the company doing business in that state or the company must be doing business in that state, or actually be domiciled there. So for the court to have personal jurisdiction, they can also, the defendant can take a formal step. So they can just say, okay, we know we've been sued in Michigan. We're going to go ahead and defend the lawsuit because we know that we should be party to it. They can absolutely do that. And generally court filings are the way that you are considered acting in a formal step. Another way to prove personal jurisdiction is through a summons. So a summons is served on a defendant. So these are things where generally, I think often a sheriff serves these, but it's a notice to the defendant that something has been filed against them. So it's got to be personally served. Someone has to hand it to a person physically in the state where the lawsuit was filed. So if I'm sued in Oklahoma, they have to find me somewhere at a mall in Oklahoma or wherever I would go to Oklahoma and personally hand me a piece of paper to say that I have to show up in court there. And corporations are required by law to have a registered person in each state that they do business, so that the summons can be served to that person and they don't have to personally go serve, Jeff Bezos at Amazon, wherever he lives. This is a difficult concept, I think, to grasp. So we'll just kind of go through it slowly and see if we can work it out. But there's also called a long arm statute. So if a defendant doesn't live in the state, they don't do anything to defend the lawsuit. So they don't take that formal step. And if they can't be served a summons because they're not physically in the state, only then can a court sort of proverbially reach out with a big arm and say, no, we want you here. You have to be here to defend this lawsuit. That's called a long arm statute. So in order for a court to be able to reach out and grab someone and say, you need to come to court, we're requiring you to be here, that defendant has to have minimum contacts in that state. So there is a case that explains this. This case is called International Shoe Company versus Washington. And this case is discussed on page 63 of your book. And I encourage you to read that entire case. I am going to give really, really condensed facts. So International Shoe Company had a manufacturing facility and made shoes, and their entire corporation was in St. Louis, Missouri. The products were sold nationwide, however. There weren't offices or warehouses in the state of Washington. International Shoe Company did send about a dozen salespeople on a relatively continuous basis to Washington State. Those people rented hotels. They took orders for shoes or other products. They rented space inside businesses and they displayed products. They didn't take any payments. So that's what they were trying to not do, to do business in the state of Washington, is not take payments for any of the stuff that they were doing. So Washington requested that the International Shoe Company pay unemployment fees because they're working in the state. And International Shoe said, no, we're not going to do that. So Washington State sued them. The court said that International Shoe did have sufficient contacts to justify the lawsuit. And so a judgment was entered against them. Of course, International Shoe Company appealed that decision by the court. And then the issue on appeal, so the issue that International Shoe Company asked the court to decide was, did International Shoe have the minimum contacts required for that long arm statute for Washington to say, no, you have to defend this case here. You actually should be, we do have personal jurisdiction over you. Do you think, what's your opinion after reading this case? Do you think that all of the things that International Shoe had done, that they actually had jurisdiction, personal jurisdiction in Washington? Give you a second to think. That opinion, you can read the entire court's opinion on 63. but kind of thinking about what your own opinion would be based on the facts that you know. International Shoe themselves, they argued that their presence in the state is not enough. Just for us to be there doesn't mean that, that you have personal jurisdiction. The court said in this next section, in the quoted section, to the extent that a corporation exercises the privilege of conducting businesses within a state, it enjoys the benefits and protection of the laws of that state, and the exercise of that privilege may give rise to the obligations. So essentially what they're saying is, what you were doing, your activities in the state of Washington they were systematic and they were continuous throughout all of the years in question that Washington is asking you to pay unemployment tax. Because International Shoe could use laws of that state to protect themselves, so under contract, under torts, which mean absolutely nothing to you at this point in the course, but they were able to use Washington state laws to protect their own business interests against consumers or other people. They're also obligated by the state for the same reason. So the court said it's affirmed the decision that you were liable to the state of Washington is in fact true. So then we have a discussion of appellate courts, which is what we just saw in International Shoe. These are higher courts that review to see whether the trial court made any errors. So there's no jury in an appellate court. It's generally 3 or more judges, and that depends on the kind of court or what their rules are. So the Court of Appeals takes all of the facts as determined at trial. They don't make up any additional facts. They don't change any of the facts. And they take those facts and they see if the trial court applied the law correctly. If there was an error of law, they may require a new trial. If they find there was no error of law, they may affirm the judgment. But it's important to know that in a court of appeals, there are no witnesses called, there's no evidence shown, that sort of thing. It's just a review of the court's decision. So, which is, I think, what I just said here. Well, there are witnesses, testimony, there's evidence, all of that stuff that you normally see in a trial that you're probably familiar with. In appellate courts, these are argued by briefs. So these are written arguments on the case. They're given to the court for them to review. And then when your time for court is called, each side gives an oral argument, which is about 15 minutes. It depends on the court rules. And then if that panel of 3 or more judges, they review the briefs, they listen to your oral arguments, and then they make a decision on the appeal. So our federal courts, so we have federal and state courts. The federal courts are established by the Constitution, and there's 2 kinds of civil lawsuits heard in federal court. There are federal questions and there are diversity cases. So federal questions means that there's a claim based on a federal statute or like on a treaty. So let's say, for example, this is an example here. If the Environmental Protection Agency asks a logging company to stop logging in a national forest, these are based on national statutes, on federal statutes, and federal courts will hear it. But in our case, with Tony, with Beth Smiles and the insurance company, it's not necessarily a federal question. The federal court doesn't necessarily have jurisdiction over this particular case. It's possible that they do, but they can also file in state court because there's no federal question. So diversity cases are also the other case that's heard in federal court. So this applies when the plaintiff and defendant are in different states. Also, the amount of money in dispute has to be over $75,000. So in the case where we're talking about Beth and Tony, Beth's company, EnviroVision, is located in Oregon, and the insurance company is headquartered in Georgia. So she could file this in federal court. Does the state court have jurisdiction over the insurance company? These are questions to think about. Does Georgia state court have jurisdiction over Beth at EnviroVision? Where should Beth where should Janet Booker file the complaint and why? Well, Janet should file in, she can file in one of two places. She can file in state court, because we know that now, after a couple slides ago, that the insurance company has minimum contacts in the state that Beth lives in. They do business there. She's a client of theirs. They've sold policies there. Maybe there's an agent in town for their insurance company. But she could also file it in state court, because they are, I'm sorry. She could also file it in federal court, because they are citizens of two different places. So for federal trial courts, you have the United States District Court, and we have 94 districts in the United States. And they're split up by population. So Kansas, we have 1 district, and Texas has 4 districts. So like it'd be the Eastern District of Texas, that sort of thing. But Kansas only has 1. We do have 3 different courts. They're in Kansas City, Topeka, and Wichita. U.S. presidents nominate all federal judges, and they serve for life. There are federal appellate courts. So you have the United States Court of Appeals, and these are called circuits. So Kansas is in the 10th Circuit, and there's actually a diagram of this and all of the circuits on page 67 of your book. Kansas is in the 10th Circuit Court of Appeals, and I'm fairly certain that the actual physical place where you file those pleadings is in Colorado. But there are 11 total districts that cover the 50 states. There is a 12th Circuit Court of Appeals that covers only Washington, D.C., because it's not a state. And then there's a 13th Court of Appeals that hears specialized stuff. So like a federal tax case, or I think if we come back up here, there was some specialized bankruptcy court, foreign intelligence, things like that. And obviously we have the United States Supreme Court. It's the highest court in the country. It has 9 justices, and they can decide if they want to hear a case. They don't just get handed cases. They decide what they want to listen to. So a party has to ask the Supreme Court if they will hear their case. And that filing is called a writ of certiorari. So the court receives thousands of those every year, but they generally accept less than 100, which is why they're probably the more famous cases that you hear of, like Roe v. Wade, Brown versus Board of Education. These are Supreme Court issues. So there's actual how to do things in court. It's called, the book refers to it as litigation, but in law school, it's called civil procedure. That's the procedure of how things go in court. You have pleadings. Pleadings are the actual things that you're filing in court. So it's the actual complaint. The complaint is what the plaintiff, so the person who wants to sue, they file a complaint against the defendant who wronged them in some way. There's a short statement of facts about what that person believes that has occurred, and then the legal claim that they're making. So in the sample case with Beth and Tony and everyone, Janet Booker files a complaint against the insurance company. She chose federal court on Beth's behalf. And that complaint is actually listed on page 69 in its entirety, well, the sample of it anyway. So it lists 1 through 7, the facts at issue that she believes occurred on the case in the matter of law that she believes that's applied here. Once the plaintiff files that complaint in court, Janet will receive the summons, and you get that from the court. And it's a piece of paper that orders the defendant to answer the complaint within 20 days. Copy. The sheriff, or a process server, who's generally sheriff, has the complaint and the summons, and he takes those two things that are usually stapled together, and he takes them to the defendant's house or place of business, or wherever that person can be located, to officially serve them. Once the person's been served, So in our case, once the insurance company is served, they have 20 days after they receive the complaint and summons, once those things are filed, to answer. So they have to file another pleading, and that pleading is called the answer. The answer tells the court the facts that are in dispute. So in our sample case, the answer is listed on page 70, the top of page 70. So if the defendant does not answer the complaint within 20 days, the court will issue a judgment. It's called a default judgment. And that means that because they didn't defend themselves, the court had proper jurisdiction, they were properly served, then the plaintiff wins without a trial. So that means that everything stated in the complaint, the judge says, yep, what you said is right. They didn't defend themselves, so you win. Those happen all the time because generally, I would say they happen in a small claims court. So a person gets sued over a credit card, or I'm trying to think of all kinds of tiny things. I would say these happen, I see them a lot in credit card cases. They'll serve a person, a representative from Capital One shows up, and the person they're suing does not show up. So the judge on the summons, it says your court hearing's at 9 o'clock on a Tuesday. 9 o'clock on a Tuesday rolls around. The judge looks at the case and says, well, it looks like everything Capital One said is right. They win. And so then there's a judgment entered against the person, and that person is, that's when you see, and this is often when you hear people complaining about businesses taking money out of their accounts, or they'll all of a sudden get a letter that says they owe $10,000 to a credit card, something like that. It's because they did nothing. It's because they choose to not show up to court. And then the response is, well, then you lose. So technically the answer the insurance company will have 20 days for the answer. And then they have to serve that back to the other side. The answer tells the court, I just talked about that. But what they can do is you can counterclaim. So sometimes the defendant can do, so they can answer it, and then they can say, okay, we accept the fact that you're suing us. Now we're going to sue you back for some other reason. So when the plaintiff gets that, liable case or whatever it is, they have 20 days to respond to it. So just like the other person, it's kind of a volley back and forth. So, and that's only in counterclaim situations, which don't happen all the time. And then this, we should have completely thrown this out because I think it just throws in something here that doesn't need to be, but class actions. It means one person represents an entire group of people. And I think a good example lately would be the Flint water crisis. So one person, which in that case is Melissa Mays, she represents a group of hundreds or thousands of people versus lots of other people. So the case reads, Melissa Mays et al., which it means and others, versus the governor of Michigan and others. And there's a link there to kind of understand what that's about. But essentially, they just settled that last month or this month for $641 million, split amongst, however many people were in that, in the Melissa Mays part of this, minus the attorney's fees. Actually isn't a very big settlement, actually. So another thing that happens after or during the court process are motions. So a motion is just one of the parties requesting that the court do something. So either stop something or issue an order, that sort of thing. So there's a motion to dismiss. There are motions to compel, which means you move the court to make the defendant do something, or a motion to strike the record, which often happens like in the middle of a trial. But there are all kinds of motions that happen before, during, and after litigation. So I think the most fun part, and most interesting part anyway, of trial law is the discovery phase. So the best outcome that you can ever ask of a case is to have it settled. And generally, if both sides understand what's at risk or what both sides' argument is, then the chances that they might be able to resolve that case are much easier during this phase. So before trial, that means before they get to trial, both parties have to know all of the evidence. There are no surprises in court. And I think TV lies to people thinking that that's true, and it's not. All of this exchange of evidence is called discovery. They're discovering the argument for both sides. They're discovering the evidence. There are types of discovery. So when you see people recorded in a conference room talking about a lawsuit, that's one party's lawyer questioning another party under oath. So it's not in court, it's relatively informal, but there's a court reporter there. There are lawyers present. They're often videotaped. The plaintiff and defendant are generally there. And then, whoever is being deposed, even if it's not the actual plaintiff or defendant themselves, you can depose hundreds of people in a case. There's a production of documents and other things. So each party is going to file pleadings in court, and they'll ask for a list of documents or a list of things that they want to see. So say there's a car accident. We need to see the bumper. We need to see the car. Or we need to see a copy of the contract, or I need to see all of the emails sent between these two people, or that sort of thing. Or they might ask to say that they want to see a particular piece of land at issue, or they need to examine certain witnesses. This is where they'll also get a list of the things or the list of people they may want to depose. So if we look at our example case, Janet Booker, who is Beth's attorney, is going to send interrogatories, which are a list of questions, to the insurance company. And she's going to ask for production of documents. So she's going to ask to know who are all the people that made the decision to deny the claim. What experts do you plan to call at trial so that we can depose them? What facts did you rely on? And then the insurance company is going to do the same to her. So there's an exchange, both sides exchange them. So they'll generally start with a notice of deposition. So they're going to depose Beth, and they're going to, ask her whatever series of questions. Then often what insurance companies will do, both sides will do this. It's not just an insurance company. I think just for the purpose of the slide, this was put in there, but they may send Beth a notice, and then they'll send a notice of deposition for 25 other people. Now, this is a chess play. Why would they do that? They would do that because Beth is required to be at every deposition by law. So she's going to have to come to her own, plus any other deposition that they impose on the other side. This is the stage where there's lots of lawyering, there's lots of trickery, there's lots of I've heard people call lawyers bulldogs, all kinds of crazy stuff. This is the stage where that stuff occurs. This is where some of the best lawyers shine, in my opinion. It's a fun stage of the case. It's also where a lot of settlement offers will happen. So once you get a list of the questions that you want to know from each side, it can make people understand that maybe a whole lot of things are going to come out into court. For example, maybe in our case, and they're not currently in the facts, but maybe in our case, Beth was having an affair with Tony. We don't know that. There's no statement of that anywhere. But a lawyer can make an implication of those things in deposition, and they often will, to make any person look bad, to bring anything up. And if maybe Beth was, she may drop the case and say, this isn't worth it. I don't want my husband to leave me. I don't want anyone to know about these things. And she may drop it. Once lawyers find out little things like that, they will dig in and try to use those against the other people. It happens all the time. And this is often where settlement offers occur. So both sides start exchanging facts, and they see whose case is better, kind of what's happening. And then generally one side sees what's going on, and they say, okay, we need to go ahead and get this settled. So in our case example, Beth's lawyer gets the list of questions or the interrogatories from the insurance company. And the information that they provided really didn't give Janet anything to work with. They just said, well, he killed himself because business was bad and he didn't like his wife. And so she calls them. His name is Rich, and she just calls him on the phone. This is how this works. She calls Rich, and they're probably friends. She calls him and says, Rich, this is ridiculous. You have no evidence that he killed himself. You know that Beth's going to look great in front of a jury. You know that a jury won't believe that he killed himself. And Beth will look wonderful on the stand. She's very likable. People believe what she says, and a jury will pay her. So Rich says, well, Janet, let's just save ourselves some time here. My client said that I can settle this case today, right now, for $100,000. What do you want to do? And so, whether Beth decides to or not, she has to tell her client that an offer's been made, so that they can make a decision together. But these phone calls happen a number of times throughout a case. Letters, phone calls, all sorts of things are exchanged to negotiate out-of-court settlement. But what kinds of things should each side consider? So Beth needs to consider how much time she can spend doing this. How much time can she not have money coming in the door? If she's got to be out of the office all day for all of these depositions, how much effort is she going to have to put into it? Will some of this embarrass her in some way that she doesn't want to come out in public? Say, for example, if she was having an affair, could it come out? It's possible. The list could be enormously long. But what factors then should the insurance company consider? Generally, theirs is time and money. So how much time is it going to take this to trial? Because their lawyers are paid obviously by the hour, not by the settlement or by the jury award, which is what the plaintiff is awarded. So they're going to look at the actual evidence and they're going to say, okay, well, what's a jury going to do? Juries generally don't love gigantic billion-dollar corporations versus one lady who's crying on the stand because her friend is dead. A jury will not like an insurance company. And I used to work for a plaintiff's firm. I used to work for insurance company attorneys. And, winning is once in a blue moon at trial, because nobody wants to hurt the individual. And we have a general disposition to try to award individuals money. And this is especially true in the South. I'll probably talk about this more in class, but juries in the South are terrifying to large corporations. So their interest is in settling this out of court, but plaintiffs know that. So they know that that these guys don't want to go to trial. So once all of the things are exchanged, then each side files what's called a summary judgment. So one or both sides, they have all of the evidence, they have all of the depositions, they have all of the discovery that they've exchanged back and forth. And so then they file a summary judgment, a motion for summary judgment. And this is asking the judge to say, hey, none of the facts are in dispute. And since there are no facts in dispute, then we don't need a trial. So if the judge allows the summary judgment, if he says, yes, that's granted, then the case is over. It never goes to trial. But if it's denied, then we actually go sit in front of a jury trial and continue on. And settlement process those occur up until the second a jury comes back from deliberation. Let's see. So, and I think summary judgment can be confusing too, because essentially what you're saying is that here's all the evidence that he actually died by suicide. It's clear, it's convincing, no jury could find otherwise. Well, then we have to allow summary judgment, because then, there's no issue of fact that he could have died any other way. That's what that means by there are no facts in dispute. We'll settle there for today, because the next part then would be the actual trial litigation. So this is all pre-trial litigation, which is just a lot of paperwork and phone calls. So we'll probably discuss the second part of this chapter in the next class. So let me know if you have questions while you're going through things. Just email them to me, whatever works for you.